We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. Verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m.
Welcome back. A little breaking news out of Minnesota, where Derek Chauvin, a former Minneapolis police officer convicted of the murder of George Floyd last April, just filed for an appeal. And he filed these documents on his own. He claims that Judge Peter Cahill abused his discretion when he denied multiple defense motions for a change of venue because of pretrial publicity before his trial. He also claims that Judge Cahill should have been, the jury should have been sequestered, and Judge Cahill should have sequestered them during the trial. Chauvin filed his appeal by himself because his attorney, Eric Nelson, is no longer on the case. Chauvin's defense was funded by the Minnesota Police and Peace Officers Association Legal Defense Fund, and according to the motion filed by Chauvin, after he was convicted, they were no longer obligated to represent him. Derek Chauvin was sentenced to 22 and a half years for the death of George Floyd. Former prosecutor and trial attorney Rosalind Charles is here, and trial attorney Michelle Thomas also still with us. This is the motion that he filed in district court, and he's asking basically for a stay on his appeal until it can be determined whether or not he should be eligible for representation, saying that he has no money and he needs a lawyer. He would like a lawyer. He's asked for one, and they're not going to give him one. And so he's saying at the end, after he goes on to say how he has no money, that he would like the appellate brief to be stayed upon the Minnesota Supreme Court's review of the denial of my application for an appellate public defender. Rosalind, so for people to understand that he had, Eric Nelson, who we all watched defend him during this trial, that's over. After the conviction, the Peace Officers Association says, no, we're not doing this anymore. And now he's incarcerated and he's sentenced. Is it totally up to him to come up with his own appeal, or do you think that he should be eligible to get some sort of public defender to help him with the appellate process?
Well, I'm going to use the standards that are utilized here in the state of New Jersey. And even during the appeal process in the state of New Jersey, the public defender does have an obligation to represent indigent people who can't afford attorneys during their appeal process. How that works in Minnesota, I'm not absolutely sure, but I do find it somewhat unreasonable that he was denied an application for a public defender. He is entitled to a defense, and that's pretty much the bulwark of our system, is that you should be adequately represented during a criminal process. So he's not off the mark. I hesitate to find myself in a position of defending Derek Chauvin, but in terms of the principles for which our system stands on, yes, he's entitled to competent counsel. And I seriously doubt that Chauvin is capable of representing himself adequately through the appeal process.
Michelle, your thoughts on this?
Well, it's true that in a criminal case, our system is designed to ensure that defendants have competent counsel. As for the reasons for the public defender's denial of his request for appellate counsel, that we don't know. I think that the public defender's office has every right to deny cases based upon whatever criteria they have set forth. As to his request to stay the timing, or to toll the timing for filing his appellate brief, that's a reasonable request, and it will be up to the Supreme Court to decide whether that should be reviewed and he should be assigned counsel by the public defenders. But I don't take issue with the public defender's decision at all, because it is their right to make that decision based upon their criteria.
Yeah, and if everybody who's been convicted and is sitting in a prison everywhere in this country had their own lawyer that they could just call all the time, that would be a system that would go nowhere. And so there has to be some sort of barrier, and for whatever reason, he has not broken through that barrier, at least at this point, with the Minnesota Public Defender's Office. Let's take a listen to Derek Chauvin speaking during sentencing. You'll remember this. Take a look.
At this time, due to some additional legal matters at hand, I'm not able to give a full formal statement at this time. But very briefly, though, I do want to give my condolences to the Floyd family. There's going to be some other information in the future that would be of interest, and I hope things will give you some peace of mind. Thank you.
Derek Chauvin, not the only officer obviously involved in George Floyd's death. As we look forward to the pending trials for the other 3 officers, Rosalind, they're different cases, are they not? And what we saw take place in the Chauvin case was the person at the defendant's table was also the person who had a knee on George Floyd's neck and a smirk on his face. It is not the case. It won't be the same case the second time around. What about the other trial, which for the other 3 officers, and the strength of the state's case that they aided and abetted Derek Chauvin in the death of George Floyd? What's your take at this point in terms of the strength of the state's case?
That's a tough question. You know, this case is the case and cases have received a lot of notoriety, and since that time, many police standards have come out that's saying that you should, in other words, you should not participate in such kinds of activities. You've got young officers on the scene who were, if you will, potentially obeying a superior officer. But to what degree do you go down that road? So I think that the prosecution ultimately will prevail in these cases, but the defense will also have a lot to work with in terms of what they actually did in participating in the what became the death of George Floyd. So these are going to be tough cases, and they were rightfully severed from Chauvin's case.
But Michelle, not severed from each other, and the 3 have different stories, right? Tou Thao's over on the side, never physically touches Floyd. He may have something to say about his involvement, that he was so concerned with the crowd. And then you have King and Lane, who were, Lane was all the way down. Maybe he's got a different story to tell in the way that he did articulate, hey, should we get off this guy? Once, maybe twice, depending on your interpretation of the video. How does that complicate matters for those 3, trying to differentiate yourself from maybe the others or one of the others at trial?
In a case like this, where you have multiple co-defendants who are facing these kind of charges, what happens is the defendants will oftentimes start to turn on each other. And so it complicates matters when you may have conflicting stories start to arise, or there being blame pointed at one defendant versus another in order to save themselves. So it can sort of muddy the waters from that standpoint, and their defense attorneys have a hurdle that they will have to overcome in order to differentiate their client from the other co-defendants who are also facing those charges.
Let's go back and listen to Eric Nelson articulating to Judge Cahill at the time that this is a mistrial, and Judge Cahill's response.
All right, a couple of things. I know the defense was in the process, I think, of making expressing a concern or an objection to counsel's argument belittling the defense. Is that what I correctly perceived that objection? I think we dealt with it sufficiently during the objections during the rebuttal. So there will be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct and is potentially basis for grounds for a mistrial.
Okay, I think the use of the word nonsense was what you're talking about originally.
Originally, Your Honor, but then in rebuttal, there were repeated comments about how we were, and implications that we were shading was one example, that we were creating Halloween stories was another example, that these were stories, and that was a repeated comment. Stated that we misrepresented facts and put words into Dr. Baker's mouth, that we made several statements that they put forth as stories. After the court instructed him to stop using the word stories, he clarified that it's just fabricated facts. And so there were multiple references to that, that we were shading the truth. There's lots of law in this, Your Honor, and essentially these comments, the repeated comments, constitute prosecutorial misconduct.
I'll note for the record that I overruled the first objection when Mr. Blackwell used the word story because it was isolated and in its context it did not seem to me to be belittling. However, the continued use of it, I did sustain the ultimate objection that counsel made to the use of the word stories and instructed the jury to disregard it. Also on shading the truth, that I sustained the objection and instructed the jury to disregard it. I'm not making any findings as to whether it was the type of prosecutorial misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard.
Rosalind, Judge Cahill, he's going to be back for the other three. What's your overall take on the way he was able to negotiate such a high-profile trial with so much at stake?
Well, in general, I believe that he did a good job. Yes, there were some issues. There are always issues that arise in trials which are potentially appealable issues, or indeed are appealable issues, but ultimately any appellate division is going to have to decide, will any of the alleged errors made during the course of the trial, did they resound to the detriment of the defendant, as well as the constitutional principles upon which our trials are based upon. The objections that we observed here dealt with the prosecutor's characterization of certain testimony that was elicited by the defendant, but ultimately it dealt with credibility. And that credibility issue was left to the jury in this case. So I believe his rulings, at least on those issues that we were just shown, were appropriate.
Yeah, we will likely see a lot more of Judge Cahill in the coming year when the other three officers face trial. I want to thank Michelle Thomas for her time this morning. Really appreciate it.